back and thank you for staying tuned. Of course, we're slowly getting to the end of today's broadcast. We still have Barrister Chidi Ujoatumba here, human rights lawyer, and still trying to just briefly assess this. Of course, we'll go into detail on this tomorrow. Mazi Nnamdi Kanu and his continued incarceration. Now, a lot of people who have been following this case and support the IPOB leader believe that this may be his final, ordeal. I mean, having been incarcerated for no less than 10 years. Building up to this period. Essentially, do you see Mazi Nnamdi Kanu ever leaving the DSS custody and actually coming back into society, judging by the terrorism charges leveled against him?
I do a lot. They will not keep him there forever. They don't even have the constitutional powers and rights to continue to be keeping him in incarceration. Like I said earlier on, the law makes it that you can keep someone under, mind you, he is not in prison. He is under DSS custody, not in prison. So that one alone, that's house arrest. You understand? That's unlawful. That's unlawful because if you arraign someone for a bailable offense, okay, the person can say, I want to appeal. I want to apply for my bail. Okay, I'm entitled to bail. So I can. Do you know that Mazi Nnamdi Kanu was never given the opportunity to prepare for his case? He was being tried under incarceration. He was being tried under DSS custody. So I am very, very optimistic that as the case crystallizes, as the Nigerian government have seen the weaknesses and the strength of their case, okay? And as the time that he has stayed in incarceration is long and overdue, they should use this no case submission, you understand, as a kind of as a way of letting people know that it's okay, let him go. Because if I get a copy of that no case submission for you to study, there's an aspect of it that really baffled me. The statements that were made by the witnesses, those who were not document witness, eyewitnesses, those who say that he made call, those who say that they listened to him, you understand, broadcast that so many things should be done. Those who say that the DSS never investigated nothing. Do you know what they did? They came to court and they replicated those hearsays that they heard from people. None of them were investigated. I've looked at the whole case. The no case submission was an apt activity, legal activity for Agabi to do. You understand? Because there is nothing to call him to come and defend himself on. And based on that, I think he should be released on the 26th. The no case submission should be sustained. You understand? And then he should be discharged and acquitted. And if that is done, you will never bring terrorists. So you will never bring terrorist charges
because
against
of the
him
lack of time. I mean, the case was moved from abridged to 26th of this month. As a legal practitioner, what are the grounds for such a situation that the case earlier adjourned will suddenly be brought closer? I mean, for yet to be explained reasons. Do you think what do you think are the factors to consider? By the
privileges of a judge sumotor on his own can abridge the time.
What are the grounds?
It's legal. They are called judges' privileges. It's their privileges. Okay, they can do it under what we call practice and direction. Okay?
Should we be concerned about Mazi Nnamdi Kanu's health based on this?
Yeah, I'm coming to that. Under practice and direction, the judge has the right to invite the two parties and say, my ruling is ready. Because I am done with it, okay? I should have given it 2 weeks in the future, but now it's ready. So a judge can do that. Now, it can also be done by the application of any other party, either in respect to the health of a particular party. You understand what I'm talking about? So if Mazi Nnamdi Kanu have not been feeling fine and the lawyers knows that there's a need for him to either be flown abroad for medical checkup or for him to properly be taken to a hospital to be taken care of, based on that, they can apply for the time of that ruling to be abridged. So a party can do it, a lawyer can do it on behalf of his party, and a judge can do it based on his own authority as a judge. So I let's wait and see how the ruling comes out to be on a Friday. But I know that there's nothing illegal about abridging a time because it's quite provided in the practice and direction. Yeah.
Right.
That's great. I want to break your mind a bit before we leave, right? Do you think the Nigerian state is under tense somewhat? Okay, we can actually just oppose this to what happened in Katsina. The whole peace deal with these bandits and terrorists, people you know that kill many people, right? And you're seeking a peace deal with them. And they said to you, take 10 of us and they will be uprise of another 20. Such statements, these are people you know that this is their attributes, this is what they do. What IPOB was prescribed, as you stated right now, wasn't even under the right platform.
Yeah.
It came through right. Can you just oppose all these things
it's worrisome. Look, everybody, Natalie will say, tongues have been wagging all over the north, even in the south. You understand? I couldn't, the other day on Twitter, it was buzzing. They couldn't allow me to rest. You are brandishing a well-known, I wish I could stand up and say this, a well-known terrorist brandishing AK-47 was sitting with governmental officials, and they were negotiating and talking and trying to reach an agreement on how terrorists and bandits will allow farmers to go back to work. You understand? And you look at it, are they not terrorists? Are they not brandishing AK-47? Who gave them that gun? Where did they get them from? Where is the security apparatus of this country? And on the other hand, you see someone who is clamoring and campaigning. What Nnamdi Kanu is doing, is it different from what any other nationalists have done? What he's doing, is it different from what Awolowo and Zik and Saddam Sokoto did? Let my people be. Let my people go. We are being marginalized, okay? We are being killed for no just cause.
Okay.
We want to stay on our own.
All right.
So I don't see anything wrong with it.
We're out of time, Barrister Chidi, but before we let you
This
go,
needs our time.
in the build-up to tomorrow's special conversation, which we would have on this Mazi Nnamdi Kanu's trial, the headline here, and we have to break it down because we're not all learned colleagues, we're not all legal practitioners. Courts to rule on Nnamdi Kanu's no-case submission September 26th. In just a few words, what does that mean, that the court would rule on his no-case submission?
It means that his hearing or his prosecution has been concluded, and instead of him to open up a defense, he said, I don't have anything to defend. You never pointed anything to me. So discharge and acquit me. So on that day, the judge will now rule on that application to discharge him or to acquit him.
All right, Barrister Chidi. Definitely, this is going to be the way we'll start tomorrow's show. The late tomorrow. Thank you, Barrister Chidi, for joining the show today.
For having me.
It's always great to have you.
Always a pleasure.
Leaving us touch up. Yeah, so yes, it is of course the ruling and not the hearing. His case has been heard. Yeah. So we're going to see how that builds up. We'll start tomorrow to watch Mazi Nnamdi Kanu's space in this ongoing trial. Until we meet again, same time tomorrow, same channel, I remain your host, Natalie Uku.
And I remain OG Nwachukwu. Have a great one. Bye for now.